Welcome to Emerging Issues in Afghan Asylum Adjudications, sponsored by the ABA Commission on Immigration. To receive CLE credit, you must attend the entire program. Partial credit is not available. Please click on all participation verification alerts to confirm your attendance. After the program ends, a link to complete the certification process will appear. Please complete the evaluation and the CLE affidavit, providing your bar information as requested, and submit. Once your attendance is verified, your certificate will be emailed to you. Moderating the program today is Emily McCabe. Emily is a senior staff attorney for the Family Group Legal Orientation Program, FGLOP, at the American Bar Association's Commission on Immigration in Washington, D.C. Emily, you may proceed with the program.
Thank you so much, Debbie. And I'd like to briefly introduce our wonderful panelists. Um, Joining me on the program today are Rachel Zoglin Bautista and Anwin Hughes. Rachel is the Associate Director of Pro Bono and Partnerships at HIAS in Silver Spring, Maryland. And Anwin is the Director of Legal Strategy at Human Rights First in New York, New York. And please feel free to read their extensive bios online and in the materials today. And I will pass it over to Rachel and Anwin.
Thanks so much, Emily. Just a quick overview of our presentation today. We're going to go over some of the one-year filing deadline issues for asylum that we've seen come out in Afghan asylum cases lately. Talk about these issues and some strategies that attorneys and advocates can use to overcome these issues. Then Anwin's going to take it away with the really interesting stuff, I think, for this presentation about really some of the bars to asylum that we're really concerned about with this population. The terrorism-related inadmissibility ground bars to asylum trig, potential persecutor bar issues, as well as some of the criminal bars, including the serious non-political crime bar and the particularly serious crime bar. And then talk a little bit about some of the trig exemptions that have been granted by the administration. And then we'll kind of round out the presentation today talking about what to do if clients' affirmative asylum cases have been pending longer than the 150-day deadline that was set by Congress, what to do about that and some strategies to consider, as well as considering TPS, temporary protected status, for Afghans, including Afghans who are also applying for asylum. So some of the pros and cons of that. And then hopefully we'll have some time at the end of the seminar for Q&A. So just to briefly talk about the one-year filing deadline issue. Generally, if folks are familiar with asylum here on the call today, you know that an asylum seeker must apply for asylum within 1 year of their last entry to the United States. There are some exceptions to that 1 year filing deadline, including changed circumstances, either in the applicant's life or in their country of origin, as well as extraordinary circumstances. Those generally deal with their ability to apply for asylum. One of the extraordinary circumstances that is specifically outlined in the regulations is if somebody is maintaining another form of lawful immigration status in the United States, including temporary protected status or parole. And so, really within the regulations itself, it envisions that parolees, if, throughout the validity period of their parole, enjoy a tolling of this 1 year filing deadline requirement. Um, they those individuals should still plan to apply for asylum either while that status is valid, so while they're still in valid parole status, or within a reasonable period of time of the expiry of that status. So what does this mean as a practical matter for Afghan asylum applicants? generally speaking, we're really encouraging folks to apply for asylum while they're still in valid parole status. Part of the reason for this, and we're going to talk about it kind of at the conclusion of the seminar, is um, for purposes of maintaining their employment authorization continuity. Um, their their current employment authorization documents that are based on holding parole will expire when their parole expires, and so they need to make a plan to, if they're working, if they're using their employment authorization, to be able to continue working, to have another basis for employment authorization. Um, but they can still, of course, apply within a quote reasonable period of time of the expiry of their parole and still be eligible for asylum. What are we seeing with Afghan asylum applicants and this 1 year filing deadline issue? Even though many Afghans are applying for asylum now, they still validly hold parole. It's within the regulations that they're still eligible. This should be told, um, you know, kind of automatically. What we're seeing is that asylum officers are really asking, they're kind of hammering down hard on this question. They're not taking for granted that this is that Afghan parolees, qualify for this regulatory exception to the 1 year filing deadline. So, um, we really encourage attorneys to work with their clients to be able to understand that even though they do qualify for an exception to the 1 year filing deadline, they should expect questions on it from the asylum office. And they should be prepared to answer why they didn't file within 1 year of entering the United States. Um, you know, any explanation, they still do qualify for the parole based exception here, this exceptional circumstance. Um, but they shouldn't plan to just have that be their response. So um, folks should be prepared to explain what they were doing within this first year of their entry, why they were unable to submit their application within 1 year. Maybe they had a hard time finding an attorney. Language barriers can be a huge issue. Um, Maybe they were working with their resettlement agency or a nonprofit organization who had it took a long time to be able to find an attorney who could represent them pro bono. Maybe it took a while for the pro bono attorneys to get the application together. Whatever the situation is, uh, make sure your clients are ready to answer this question and really answer the question in a way that's not just, well, I'm a parolee and I'm allowed to file late. Um, they should be prepared to answer kind of what it is that they've been doing uh, that made it so that they weren't able to file within the 1 year. It really shouldn't be an issue ultimately. I wouldn't expect that we're going to see denials of asylum on this basis, but just to know that asylum officers are asking a lot of questions about this. They're not just saying, "Oh, you still have parole, you're fine, you don't have to worry about the 1 year filing deadline." We are seeing asylum officers ask quite a bit of questions, really papering their file, papering the applications on this issue. Okay, I'm gonna now pass it over to Anwen to talk about the bars to asylum.
Yeah, I mean, on the 1 year filing deadline point, that's a little bit crazy, and I wonder, I might be inclined just to tell clients to say on the advice of counsel and let me do the explaining, because I mean they qualify for obviously an exception that the regulation already contemplates. It strikes me as a training issue for the asylum office more than anything else. Anyway, moving on to other bars, which can legitimately give rise to quite a lot of discussion. I'm going to be talking about the terrorism-related inadmissibility grounds, the persecutor bar, the serious non-political crime bar, and the particularly serious crime bar. Starting off with the terrorism-related inadmissibility grounds. At some point in the past, USCIS had the idea that if we could all just come up with a term to describe this subject area that we spent our time discussing and negotiating over that didn't involve repeating the word terrorism and terrorist every 2 seconds, it might help us encourage decision makers to reach more rational solutions to our statutory problems. And so they came up with the acronym TRIG. So you'll often hear people talking about clients having TRIG issues or cases presenting TRIG issues, or talking about TRIG grounds, and this stands for terrorism-related inadmissibility grounds. And I should say, why am I even talking about inadmissibility grounds in the context of a presentation um, bars to asylum? The reason for this is that, first of all, a number of you are undoubtedly helping your Afghan clients in seeking other forms of status or protection in the United States. For some of which inadmissibility is actually a relevant legal concept, such as, notably adjustment of status. But also the bars to asylum in the statute incorporate by reference in a slightly indirect way. If you look at Section 208 of the INA and 208B, you'll find that the bars to asylum that are enumerated in the statute incorporate by reference these terrorism-related inadmissibility grounds, because the terrorism-related deportability ground at Section 237A4 of the INA has since 2005 referenced all of the trig grounds in Section 212, excuse me, which is where the Immigration and Nationality Act houses inadmissibility concerns. And so, why are we talking about this, right? I mean, we're not in general setting out to aid terrorists in obtaining lasting status in the United States, whether on a pro bono basis or otherwise. So why is this such a big issue that I'm actually starting my part of this presentation with it? Well, the reason is, and it's really important to understand this, it's really important also to explain this to your clients, especially any clients for whom this may emerge as a legal problem, that terrorism for purposes of the INA does not mean what you think, or what you think if you've never been exposed to this particularly Kafkaesque area of practice. That is to say, when most of us, even in the absence of a single national or international legal definition of what terrorism is, most of us, when we use the term in common speech, are referring to violence that is broadly seen as illegitimate because it's being used to target illegitimate targets, and it's being used as a tool for illegitimate purposes, right? And in the immigration, so for example, deliberate targeting of civilians for purposes of instilling terror in a civilian population in order to achieve some other political goal is the kind of thing that most of us would naturally put in the terrorism basket when we're thinking about it. The INA, on the other hand, decided not to worry itself about the subtleties of definition and instead gave us a terrorist activity definition, which I've reproduced on this slide, and which prohibits any activity or defines as terrorist activity any activity which is unlawful under the laws of the place where it is committed. So if we're talking about people who may have been involved in or adjacent to acts of violence in Afghanistan, if it was unlawful under Afghan law, for example, or which, if it had been committed in the United States, would be unlawful under federal law or the law of any state, and which involves ... the use of any weapon or dangerous device other than for mere personal monetary gain with the intent to endanger, directly or indirectly, the safety of one or more individuals or to cause substantial damage to property. Now, pause and consider the swaths of human activity, right? Some of it legal, some of it, not necessarily legal, but some of it not. For example, it can end up covering a fair amount of armed conflict, including, for example, armed conflicts that the United States has actually engaged in abroad can end up falling under this label. So too, at least on the face of the definition, could, a barroom brawl, right? That's not violence that's being engaged in typically for purposes of mere personal monetary gain. It's being engaged in for other purposes, for purposes of, venting one's drunkenness, dealing with personal differences or what have you. It also covers what most of us would consider to be terrorist activity. And it covers a great deal else besides. And most importantly for our present purposes, it would also cover, in DHS's view, any situation in which a non-state armed group is engaged in the use of armed force against either another non-state armed group, because national laws in most places prohibit that kind of thing, or against the armed forces of a national government. And by national government, I mean any national government. I'm not saying a national government that the US recognizes, a national government that the US approves of, a national government the US has been allied against, a national government that the US has never itself waged a war against. No, I'm just talking about any established government. The use of violence in that context against such an entity, or again against some other militia, will give rise to concerns under this definition, as under DHS's reading of the statute and under the readings of the statute that have been adopted by the Board of Immigration Appeals and the courts. And the important thing to bear in mind here is that DHS understands this definition to apply to acts of violence between combatants in opposing armies, basically. And that is part of the reason why this becomes such a big problem for those of us representing asylum seekers coming out of a country that has been in a state of armed conflict in varying levels for decades at this point. Now, the reason, though, that you have to be concerned about these grounds, even in cases where your client was never himself or perhaps herself a member of any kind of an armed group or any kind of a force that used violence against other people, is because of the concept of material support. And I'm not going to read you this definition, but it's up on your slide, and it includes material support, which is defined here in a sort of non-exhaustive illustrative way. This concept of material support includes material support not just to people and individuals engaged in terrorist activity, as very broadly defined by the INA, but also to any of the types of terrorist organizations that the INA defines. In addition to this, this concept of material support, which the INA defines the provision of material support to a terrorist organization or to a person who is who the donor knows or should reasonably know has committed or plans to commit terrorist activity. That is defined as as terrorist activity in its own right. So the INA, which is in this part is really not very well drafted, has both a definition of terrorist activity and also a definition or a series of enumerations of what it means to engage in terrorist activity. And one of the things that is included in that definition is the provision of material support according to this definition. And the scope of this has been further expanded by precedent decisions from the Board of Immigration Appeals, which have held that there is both no statutory defense or no common law defense of duress to this statutory bar. And that was in a case called Matter of MHZ that came out in 2016. And following that, the BIA issued a more extraordinary decision called Matter of ACM, in which they held that the concept of material support also did not have any sort of a quantitative floor, that the term material did not carry with it any necessary implication that the support provided had to be quantitatively significant. There's also very expansive language in ACM about what types of goods or services or other assistance would qualify as material support, just in case you thought the board was open to reading some limitations as to type of aid into this definition. The second reason that these terrorism grounds end up affecting so many asylum seekers, including asylum seekers that really don't deserve this, is because of the INA's definition of a non-designated or so-called Tier 3 terrorist organization. This concept, along with this definition of material support that extended it to all types of terrorist organizations, these were both products of the USA Patriot Act in 2001. And the INA since that time has had a tripartite definition of what a terrorist organization is. And I'm going to pause on this for a bit because these distinctions can end up being very important. So first we have what the statute refers to as designated foreign terrorist organizations, and what we often refer to for purposes of classification as Tier 1 groups. So these are groups that are designated as foreign terrorist organizations. This applies to foreign groups only, under Section 219 of the Immigration and Nationality Act by the Secretary of State. And that designation has criminal consequences in addition to immigration consequences. And whatever the warts of that process, and of the choice of groups to cover, the process itself at least does have some measure of transparency, in the sense that there are some legal protections for groups that are being designated in this fashion that are baked into the statute. Groups can, dispute their classification. And when they're designated or listed, this appears on the State Department's website. And so if you're being solicited by one of these groups for, a contribution in honor of the Christmas season, for example, and you have any concerns about their identity or what this might mean for you, even as a U.S. citizen, because of the criminal implications, you can go online and check them out. And there are also some groups that at one time were listed and since have been delisted, and those delistings are also listed on the State Department's website. Then in addition to that, we have so-called Tier 2 groups. These are groups on what's also referred to as the terrorism exclusion list, excuse me. And this is a list that has immigration consequences only. These lists, which are also available on the State Department's website, although the Attorney General is involved in these listings, that's also publicly reviewable by you, but probably of less concern for you bringing asylum cases now, simply because the US government has not used this list much since the early 2000s. And the reason for that is because the terrorist exclusion list has only immigration implications. It doesn't, donations to these groups are not going to trigger possible criminal prosecution. But I think the agencies involved quickly realized that the Tier 3 definition was actually a really dandy thing for their purposes, and allowed them to do the same things that the terrorist exclusion list did without actually having to tell anyone that that was what they were doing or list the groups anywhere that was publicly reviewable. I would say that colleagues at IRAP have recently put together a sort of advocates list of groups known to have been designated at one point or another, or categorized at one point or another, rather, but as Tier 3 groups, which you can find and check out. I should have put a link to it here, but I think it may have come out after I did these slides. But the problem with Tier 3 groups is that they are actually not listed anywhere. They're not designated anywhere public, and their definition as terrorist organizations for immigration purposes is an ad hoc thing that normally happens in the context of a particular immigration adjudication and based on the evidence presented in that adjudication. Bear in mind that whether a group is to be considered a group, let's say, that your client may have been a part of, may have been recruited by, may have been given military training by, because that's also one of the trig grounds, or may have paid money to under a variety of circumstances, whether that group is going to be considered a Tier 1, Tier 2, or Tier 3 group for purposes of your client's immigration case is going to depend on how the group was considered or classified at the time that the relevant act on your client's part took place. So the question is, if for example a group was engaged in the use of armed force in an unlawful way for many years, and then in 2016, let's say, it was designated as a foreign terrorist organization by the Secretary of State, and your client had given them some sheep in 2013, that's going to be a material support to a Tier 3 group problem for purposes of your client's case, because they were not designated as a Tier 1 group until after that. The one exception to this has to do with the Taliban, who were designated as a Tier 1 group by act of Congress and only for immigration purposes rather than by the Secretary of State at the end of 2007. And that definition of them as a Tier 1 group, or designation of them as a Tier 1 group, has had retroactive effect. So what is this definition of a tier 3 terrorist organization? It's defined as a group of 2 or more individuals, whether organized or not, which engages in or has a subgroup which engages in the commission, planning, preparation, etc., or the provision of material support to terrorist activity as defined in the INA. Now, this too is a really, really broad definition. I mean, you can have a disorganized collection of humans, maybe 3 humans, 2 humans, that have a subgroup. So maybe one of these humans is engaged in the use of armed conflict and the other human is sitting there not preventing it. You can end up having that group of people be defined as a tier 3 organization for purposes of an immigration case. The Board of Immigration Appeals in 2006 considered the breadth of this in a case involving a refugee from a Burmese minority group who, while in exile in, I'm going to say, Singapore, had sent some donations to a group known as the Chin National Front, which had as a subgroup the Chin National Army, which was engaged in a very tiny amount of military conflict with the forces of a Burmese military regime at the time that the United States wasn't recognizing. And the BIA said, well, this is what Congress enacted, though, you know, the consequences of this seem awfully harsh. Note also that this tier 3 group definition is going to be applied retroactively to groups that were, for example, waging war in Afghanistan before the USA Patriot Act was ever passed. And, you know, some of the clients that we're seeing in these seeking asylum from Afghanistan at the moment, many of them are very young, but some of them are even older than I am, and you know, they do go back that far, and so and beyond. And so you just need to be aware that there are a bunch of Afghan groups that people may have had contact with in the 80s, in the 70s in some cases, in the 90s, before the USA Patriot Act was more than a glimmer in the eyes of people in Congress, and they will still end up running into problems under, or may end up running into problems because of contacts with those groups. So basically, the consequence, if you're Afghan, is that any group that ever took up arms against any established government that was in power in Kabul at the time, and that is not designated as a tier 1 group, will be treated as a tier 3 group with respect to any period of time when it was using armed force. So this means, among others, all of the various armed groups that have held sway in Afghanistan or in regions of Afghanistan in recent memory. And oh yeah, so I see Emily's put the link to this. Okay, Emily, I don't know if this is actually visible to participants, but you can find, if you go to refugeerights.org, you can find a list of undesignated tier 3 terrorist organizations, which may be helpful in your cases. But basically, most of the political movements that have also had an armed component, or armed groups that have also had a political component, depending how you want to see them, in Afghanistan since since the beginning of time, really, are going to, that were not governmental, are going to run into issues of this kind. And the Taliban, even though they were governmental in Afghanistan for stretches of time between 96 and 2001, and now again since August of 2021, are going to end up triggering legal problems under this, these definitions. So I was referring earlier to the Taliban as being a little bit anomalous in this sense, and this describes the anomaly. All right, and so I'd like you to consider now a hypothetical Afghan whom I'm calling Rania. So this is a young, educated woman in her 30s who had the kind of profile that caused many people to be evacuated in September of 2021. But and so, you know, on its face, one would think a very strong asylum claim, particularly in light of recent actions by the Taliban against women, generally educated women in particular, which a number of European countries are treating basically as persecution per se, and for women as a class. But as you're talking to your client in more detail, which is something you absolutely need to do, you're getting the facts that I have here at the second bullet point. So she'd spent her early childhood in Paktika province, which is where her family is from, and she had then gone to Kabul for education, but on a visit back to Paktika in circa 2011, she's there visiting her grandfather in the family's ancestral village, and someone from the Taliban comes to the house and demands food. This is not an uncommon scenario in parts of rural Afghanistan during that time, where the Taliban either were in effective control or thought that they should be by right, and that the local population should be natural allies of theirs, regardless of how the population may have felt about that. And so villagers who refused when people showed up at their door demanding food, would run the risk of being labeled as government supporters and suffering reprisals from the Taliban. And there's country conditions evidence that you can offer in confirmation of that fact. So when these people show up at the door, Rania's grandfather tells her father to give the Taliban a bag of rice and 2 chickens. Additional incident that you should expect would give rise to questioning at the asylum interview is that in 2021, as Rania is trying to get to the airport in Kabul in order to seek evacuation, she stopped at a checkpoint manned by Taliban and gives them her jewelry and a sum of cash to let her through. So, do we have trig problems here? I hate Zoom or whatever this platform is, CLEs, because it's much harder to ask for shows of hands, and I'm not going to try to do that because I really don't master the technology. But looking first, you really need to look at the details, because that's where the devil resides, and there are a lot of devils lurking in these scenarios. So separate out these 2 incidents. So basically we've got 2 scenarios where material, tangible stuff of some value to them flows between Rania and or her family to the Taliban. Incident 1, what do we have? What's the support in question? We've got a bag of rice and 2 chickens. Is that material support? So the Board of Immigration Appeals would say absolutely yes, right? For you, a bag of rice and 2 chickens may be supportive of arroz con pollo, but from the board's perspective, this is support. This is the support that makes the Taliban the fighting force that they are, et cetera, et cetera. So they would absolutely consider that to be terrorist, to be material support to a terrorist organization. But what does that mean for Rania? And here the important thing, and I'm flagging this type of example because I've seen a number of cases where the fine details made it clear that your client was not the person with the potential issue here, but that didn't actually come out clearly in the asylum application. So Rania had nothing to do with the passage of the rice and chickens, right, to the Taliban. The rice and chickens presumably belonged to the grandfather with whom they were staying, and her father on the grandfather's request gave this to the Taliban. Rania is out of this scenario altogether. So you just need to make sure that comes through clearly. If the officer asks specifically, have you ever had any interactions with the Taliban? And by the way, they will ask questions like this. Have you ever seen any Taliban? Did you ever, your area where you say your family is from, there were a lot of Taliban there during that period or in the surrounding countryside. Did you ever interact with them? Did anyone in your family ever interact with them, etc.? So in that situation, you just need to make sure that in the interview, these facts come out clearly. And assuming that happens, you should be completely fine. In 2021, though, you've got this other incident where Rania is seeking evacuation, and she stopped at a checkpoint, and she moved by necessity, moved by duress, moved by some forms of pressure, slightly less than that. She gives them jewelry and some amount of money. That is going to be considered material support to the Taliban, and the asylum office would consider her to be barred from asylum because of this. And the solution in DHS's view to this problem, and in the Board of Immigration Appeals view, would lie in her qualifying for a discretionary exemption, which is something we'll get to in a bit. But on the face of it, this case is not approvable based on this particular scenario. And that is true for asylum. It's true for withholding of removal. It is true for, special immigrant visa applications, not that she would qualify for that on the face of it. It's true for marriage-based adjustment of status. This bars you from almost every form of immigration benefit or relief from removal that you could imagine. An exception to that, though, is deferral of removal under the Torture Convention, but that's something that only an immigration judge can give you in removal proceedings, and only after ordering you removed. So this is actually a very big deal. Where's my next slide? Okay. And I'm going to be coming back to, sorry. I'm going to be coming back to that to talk about the exemptions towards the end of my portion of this show. Now, another bar to asylum that may come up, or the specter of it may come up, because that's often what you're actually dealing with, is the persecutor bar. And this is one that bars from asylum anyone who's ordered, incited, assisted, or otherwise participated in the persecution of any person on account of race, religion, nationality, membership in a particular social group, or political opinion. So in other words, if you have done unto others what you're complaining about others doing unto you, namely persecution, so the harm needs to be at that level, and it also needs to be on account of one or more of the grounds in the refugee definition, then you are going to be yourself barred from asylum. And the types of issues that you're going to be encountering are very similar to the types of issues that you're going to be encountering in connection with the trig bars, namely, how much of a connection, how direct does the connection have to be, and what type of connection does there have to be between your client and the persecutory act, right? In the same way that with trig, the question is, what is the connection between what your client did and terrorist activity out there somewhere, right? Assuming that your client was not him or herself wielding a gun, and you may be representing some people at various points in their life did, right? And I'm not saying they're all barred, but you do have to look with both bars at the connection between the acts that are prohibited under the INA and your client. And so in the context of the INA, how close a connection does there have to be between what you did and the acts of persecution against another person or persons in order to bar you, the actor, from asylum? And then the other question that also arises with respect to the persecutor bar, usually in ways that have been less precluded to us than under the terrorism bar so far, is the question of defenses, of which there are a number that you would think of naturally if you were dealing with these kinds of scenarios in a common law context. And the issue is, well, what legal relevance, if any, do they have in the context of the INA? So to make all this a bit more concrete, let's consider another hypothetical Afghan. And I mean, I should say any resemblance to persons living or dead is entirely a matter of coincidence, right? These are fictional examples. But they are fictional examples who have some characteristics that you may in fact see in your caseloads. So this is a man in his early 40s who spent some years as a military interpreter in Afghanistan. So he's afraid of being targeted by the Taliban based on his work with the US military, and he has an approved SIV petition, and you're representing him in an application for adjustment of status, but due to the fact that USCIS is being super slow in processing that, you're also considering filing an asylum application. And in order to do that, you're also needing to get a bit deeper into Ramazan's personal history and his employment history, which included work for entities other than the US military. So it turns out that in 2001, your client Ramazan was living with his family in Balch province when his area came under the control of forces from Hizb Wahdat, who were part of the Northern Alliance coalition, which were at the point when these incidents were happening, they were in the very final stages of their struggle to overthrow the Taliban. And these troops asked Ramzan, who lived in the area and whose father owned a small trucking firm, to drive some of their men and some of their supplies that they'd bought in the town to a village nearby. So Ramazan is Hazara. And he'd lost some family members to massacres by the Taliban. So he had no sort of natural reason to be to feel antipathy towards Hizb ut-Wahdat, presumably. And so he does what they ask. He drives them and he drives their stuff to the other village, and then he returns to their own town. Subsequently, it comes out that what these Wahdat forces actually did in that town was that they killed several civilians based on the fact that these civilians were Pashtun rather than Hazara. And they also raped the wife and daughters of one person in the town for the same reasons, namely based on their ethnicity and based on sort of sympathies with the Taliban that were attributed to them by the Wahdat people, presumably for the same reasons. So, does this give rise to a persecutor bar problem? Now, just to back this up, to start with the more basic question, suppose, somewhat unlikely scenario, right? But suppose you were a refugee officer somewhere, and one of the, or actually, no, sorry. Suppose you're a lawyer here in the U.S., and one of the people from the Hizb ut-Wahdat force that Ramazan drove is actually the person who's in your office seeking legal assistance, and you ask them about all their involvement in armed conflict while they were still in Afghanistan and still involved with Hizb ut-Wahdat, and this incident comes out. Does that person, who was actually one of the guys on the truck who then actually went into the village and was part of the force that killed these people, do they have a persecutor bar problem? And I mean, just to be super clear, yes, they do. And that is something that's not subject to any waivers or exemptions. So if they actually took part in the killing of people because of their ethnicity, or they raped people because of their ethnicity, or they aided others who did in some kind of a way that really sort of effectively moved that persecution forward, held back other people from intervening, for example, handed other people weapons, guarded the door to the house while their comrades were killing people inside. Those kinds of acts are all going to trigger the persecutor bar. But what does that mean for Ramazan, who was simply the driver in this situation? Well, that's going to depend on whether Ramazan knew in advance that this was what was going to happen, that these were the acts that he was in some sense furthering, right? And on the face of this scenario, and I would also say on the face of a lot of not terribly well done asylum applications that end up getting filed with USCIS on an annual basis, it's not entirely clear, right? So it sounds as if what happened here is that these people enlisted the help of a local who had access to a truck to drive them from point A to point B. And he drove them from point A to point B, not knowing why, right? Or not knowing what they were planning, or that what they were planning, to the extent they were even planning, more armed conflict, was going to involve civilians rather than other combatants. If that's the scenario, and he had no knowledge, that should not be a problem for Ramazan under the persecutor bar. It also, it shouldn't be a problem under the persecutor bar, because although DHS at various points in the past was taking the position that Sienter didn't even matter, they have receded from that, and there's a good First Circuit case that makes that point finally. So you shouldn't have to be worried about the persecutor bar here. On the other hand, does he have a material support problem, right? Because these people were not yet in control of the country at that point. They come to him and they want the use of his truck and the use of his services as his driver, and he drives them. The asylum office is going to look at that, and what they should say is persecutor bar, not a problem, but material support. The material support issue is actually an issue on these facts, and we will talk in a second about whether it might be exemptable. Another hypo, Sadiqullah. So he's older, in his late 50s, and up until mid-August 2021, when his life took a turn for the unexpected, he was an officer with the NDS, the National Security Directorate, in Afghanistan, which is Afghanistan's intelligence force, or I guess their domestic intelligence force, but I don't think they have a foreign intelligence force, necessarily an international one necessarily. And he has what seems like a pretty clear, easy to explain fear of persecution by the Taliban or fear of attack by the Taliban based on this. And in fact, he tells you that the Taliban have already killed or disappeared several of his close relatives, or his close colleagues, excuse me. As you dig in, though, you realize that he's been around for a while and that he was a kid in the days of the Soviet occupation of Afghanistan. And as a result, ended up getting moved with his family to Pakistan to shield them from Soviet bombing. Again, this is a fairly common scenario that you're going to see among a number of older people who were part of the evacuation. And while he was in Pakistan, based on the information you have, he worked to funnel weapons back to his dad and his dad's troops inside Afghanistan. And then much later, after going back to Afghanistan, so after the fall of the Taliban, and after completing his education there, he then joined the NDS, and he was for a while in charge of a prison in the capital of one of Afghanistan's provinces. And you ask him if he ever tortured or mistreated detainees, and he says no. But then you do a bunch of independent research, which I strongly recommend, and you find reports, human rights reporting that looks solid, that describes instances of torture of detainees, including kids who were detained because their parents had ties to the Taliban or ISIS or were alleged to, in that NDS facility during the time when Sadiqullah was in charge of it. So what do you have here? I would say what you have here is a problem in the sense that, first of all, you've got a range of possible trig issues. So your client's dad was a leader of Mujahideen forces in the Soviet era. That notice that the INA helpfully renders inadmissible people for being the spouse or children of people who engage in terrorist activity. But a child is a term of art for purposes of the INA. So once you reach the age of 21 or get married, you're no longer considered a child for purposes of that particular inadmissibility ground. And the other thing is that if the acts in question took place more than 5 years ago, or if you did not endorse them, and as a kid, your dad's not really asking you whether or not you endorse his behavior, you're not going to be having that particular complication. But later on, as a young man, and I don't know how old exactly that's supposed to make him, he himself was funneling weapons back to his father and his father's troops inside Afghanistan. And the asylum office would absolutely consider that to be material support by him, right? Now, he has to have, given that the group in question that his father was fighting with would have been a tier 3 group, right, at that time, he might be exemptable from this if he could show that the support he had been providing, that he didn't know and should not reasonably have known that the group in question was a terrorist organization. The problem is that when you're sending them weapons, at least for purposes of the INA definition, the asylum office is going to take that as, pretty strong evidence that you understood who you were supplying, or that you were supplying weapons to an armed group. And so unless you had a reasonable belief that they were actually an Afghan government force, then you would be facing a material support bar. Now, the other problem that you have is a pretty serious persecutor bar problem, because it's important to understand that the persecutor bar doesn't just bar the individual actor. It will also bar people who had what in military terms you would call command responsibility over people who engage in persecution of others. And so in a situation where you're in a position of authority and people under your command engage in acts of torture, you're going to need to really dig down into how that happened and what was your own role in that, because it's normally going to be assumed that you're responsible for what happens on your watch. And in this case, if you were actually in charge of the entire prison, right, think about this, and the problems of torture in that facility were so bad that they actually reached the ears of independent human rights organizations and motivated them to write a report about it. And if those reports are credible, then it's going to be hard for you to convince an asylum officer that you did not otherwise participate in this or that you didn't assist it, right? Because part of your job as commander of other people is making sure that they're trained not to do this, making sure that they do not in fact do this, making sure that if in a situation where something happens that was against your orders, that there are actually consequences that flow from that. So you would really need to get into all of those circumstances. But on the face of it, this would not be looking good for this particular applicant. Now, the other there are a couple of other bars that I want to touch on somewhat more briefly. One is the serious non-political crime bar. And this is going to apply where there are serious reasons for believing that the alien, the INA still says, so your client in this case, has committed, the non-citizen, has committed a serious non-political crime outside the United States prior to the arrival of the person in the United States. Couple of things to flag about this. One, this does not require conviction. So if there is evidence to show that there's what, usually you're looking at a standard somewhat equivalent to probable cause to show that the person committed a serious non-political crime outside of the US prior to arriving here, that can trigger the bar, even if the person was never prosecuted for it, even if the person was never convicted of it. The reason being that, and this bar, I should say, stems from some concerns at the time of the drafting of the Refugee Convention, one of which was to make sure that people weren't using asylum protection as a means of evading prosecution, legitimate prosecution for actual crime. The other was to make sure that states' obligations under the Refugee Convention, which the INA has implemented core parts of, including through the asylum statute, making sure that states' obligations to protect refugees against forced return didn't end up conflicting with their obligations under the various extradition treaties that many of them had signed, including with states that were themselves generating refugees that were fleeing to other states' parties. So two big questions here that you need to bear in mind. One is, and that typically arise in these cases, one is how serious is serious, right? So does this rise to the requisite level of seriousness? And there is case law that we'll look at, that will talk to you about what kinds of factors you should be looking at. But I would say always have a look at the INA's definition of what they consider to be an aggravated felony, and at the case law, the abundant and frequently confusing case law interpreting that. And just bear in mind that because something that's described as an aggravated felony is going to be assumed as a matter of statutory definition to be more serious than a serious non-political crime. So meaning that if what the person did is equivalent to something that would be considered an aggravated felony for immigration law purposes, it's going to be treated as a serious non-political crime. But there are other crimes that may fall under this heading, under this rubric, that may not necessarily meet the U.S. aggravated felony definition, or it may be unclear whether or not they would, because the laws of the country in question define things differently. UNHCR guidance talks about, when they say, what are we talking about? When we're talking about not serious non-political crimes, they usually are talking that we should be talking about a capital offense or a capital crime or other very grave punishable offense. You probably won't be surprised to hear that U.S. law has been a bit more expansive than that in terms of what types of crimes it's prepared to treat as serious non-political offenses. The other, one example involved a case that ended up going up to the Supreme Court, in a case called Aguirre, where the asylum seekers from Guatemala had been part of demonstrations in which the demonstrators had burned some passenger buses. I mean, they hadn't burned the passengers, just to be clear, but they had set fire to the buses. Um, and this was deemed to be a serious non-political crime. So the crime in question would have been arson of some degree, depending what state you're in. So just, bear this in mind when you're looking at any scenario where a client is recognizing having actually engaged in any form of criminal activity abroad, or any activity that the client may not consider criminal, but that you realize should be considered as such. The second question, and this is where you sometimes have disparities between your perception of a scenario as a lawyer and the client's understanding of what he or she was up to, is, was it non-political, right? Because of course you frequently do see people who have committed acts of violence or things that under normal circumstances would be considered crimes in very political and politicized contexts. And so there's an old BIA case called McMullen, which holds that when you're looking at the political nature of a crime and trying to decide if it should be considered a serious non-political crime or a political offense that's sufficiently political to be removed from that definition, you want to consider whether the political aspect of the offense outweighs its common law character. And what that's going to mean is that if somebody does something where the criminal aspects of what they did are grossly out of proportion to the political objectives that they may actually have had, or in situations where they did something for political purposes, but the acts were atrocious. So, the person was trying to, target a government force, but did so by knowingly lobbing a grenade into a passenger vehicle carrying a bunch of civilians. That's not going to be considered a serious non-political crime. It's going to be considered something that would bar you under this bar and also under the terrorist activity definition. Now, I also wanted to loop back to something that Rachel was usefully mentioning earlier, which is that asylum officers, and this may actually be what's going on in part with all of this time-wasty interrogation about the one-year filing deadline, asylum officers often ask a lot of questions about things where they're not asking because they're planning to come out against your client. They're asking because the system requires them to ask. They're asking because they think they need answers to these questions in order to be able to defend a proposed grant of asylum against a potentially skeptical supervisor. There are a bunch of reasons. And so sometimes, and they may also be asking because they think that your client might, may be subject to a trig-related bar, but might be eligible for an exemption, and they need a ton of underlying detail in order to be able to paper up the case for potential exemption consideration. So the fact that your client is getting asked questions about a subject area does not necessarily mean that the asylum officer is planning to deny on those grounds, right? There are a lot of people who may have worked for police forces, or they may have worked for military forces of different kinds in particular. They should expect to be getting, anyone who's ever been a combatant or anyone who's ever, worked for any entity that had as one of its functions the killing or imprisonment or detention of other humans, should expect to be asked extensive questions about this at the asylum office interview. This is not necessarily a bad sign in terms of the ultimate outcome. It's a sign that the asylum officer, assuming the question isn't wildly excessive, is that the asylum officers are doing their job. But one visual cue for you to know that the asylum office believes that this case is one that may trigger one of the bars that I'm just describing is that they will switch the interview at some point into what they call sworn statement format. And that means that they're usually typing on computers while they're interviewing your client, right? And they're typing both the questions that they ask and also the answers that the client provides, or their best recollection of what the client is saying. And when they switch into quote unquote sworn statement format, what that means is that they're going to print out the questions and answers that pertain to the subject matter that they think is of concern. And before they end the interview, they're going to ask you and your client to review that sworn statement, which is going to be in question answer format. And they're going to ask your client to sign it and to initial all the pages. You as the lawyer have both the right and the duty to review all of those notes very carefully, and you can and should make any corrections to any things that the officer got wrong. And these people are typing fast, proper nouns are often hard to hear, quality of interpreters can be variable. So anything they get wrong, you absolutely need to get fixed. You're also entitled to a copy of the statement before you leave the asylum office, and you should make sure you get it. And if you should happen to be doing the interview remotely, you should, either file a prompt FOIA request immediately afterwards so you get it, or you should ask if the asylum officer can, I don't know, they usually don't want to send this kind of thing by email, but perhaps they could fax it to you at the close of the interview. Okay, final bar is anyone who, having been convicted by a final judgment of a particularly serious crime, constitutes a danger to the community of the United States, is also going to be barred from both asylum and withhold, and in most circumstances, withholding of removal. Now, this bar does require conviction, and it is most typically going to apply in scenarios where the person has engaged in and been prosecuted for criminal activity in the United States. It's not necessarily exclusive to that, but that is the scenario where it most often comes up. I would say that what is a particularly serious crime is a little bit beyond the scope of, I think, the time that we have if we want to allow for Q&A. But anything that is defined as an aggravated felony for purposes of the INA is going to be defined as a particularly serious crime per se for purposes of an asylum application. And there may be crimes that are not defined as aggravated felonies that may nonetheless be defined as particularly serious crimes. Any criminal charges involving drugs, any criminal charges involving harm to children, any criminal charges involving sexual violence, serious assaults, murders, serious fraud offenses, theft offenses involving significant amounts of money. Those kinds of things are going to be of concern here. And so, as I think we all understand, misunderstandings can happen a lot in life generally, but they can be particularly common in scenarios where you're very new to a country, where you're emerging recently from a fairly traumatic situation back home, and where perhaps your English is not fully fluent, and where you're coming from a country whose laws may differ from ours. It can be quite easy for clients to end up getting charged for things that could have pretty devastating effects on their immigration cases, including in some cases things of which they were not in fact guilty. So it's important to make sure from the beginning of the representation that your clients understand that any interactions with the criminal justice system in this country would be a matter of urgent concern for their asylum cases, and that if any of that has happened to them already before they sit down with you, they need to tell you, because you can't help them unless they tell you. But also that if in the future they have any situations where they're being stopped by police, or they're being asked questions, or the FBI is showing up at their house, or what have you, that they should ask for a lawyer, not talk to anyone until they get one, and let you know what's happened as soon as possible. I mean, sometimes people do get charged with things in error, or in partial error, and generally as an immigration lawyer, if you can liaise with their defense counsel, make sure they have defense counsel, it's possible to ratchet down a lot of really bad situations to something that will be a lot more manageable from an immigration standpoint. All right, I'm now going to move on to exemptions to the terrorism bars. There are two types of exemptions that USCIS has promulgated under, or that actually an interagency process has promulgated under discretionary authority. That discretionary authority is housed at Section 212 D3BI of the Immigration and Nationality Act, and these exemptions fall into two broad types. One are a series of exemptions that were specific to particular groups that were deemed to be tier 3 organizations under the INA. And they, while there have been some situations where groups were removed entirely from the definition, more commonly what you have are exemptions that are group specific, in the sense that it's not that they say this group is no longer going to be considered a tier 3 group, but that's these types of interactions with this particular group during this particular time period are not going to trigger these, but are going to be exemptable. I can't think of any of those that would be relevant for people seeking asylum from Afghanistan, to be honest. So the exemptions that you should be focusing on primarily are the so-called situational exemptions, which are more sort of scenario-based, and which consider, which allow for consideration on a case-by-case basis of an exemption of a decision basically by the asylum office or by later on by a different branch of USCIS if the case should be in removal proceedings, to consider that this particular terrorism-related inadmissibility ground should not apply, even though on the face of the statute and of the client's facts it otherwise might. And most of these situational exemptions do not refer to particular nationalities or to particular country situations. So for example, if you want to go back to Rania, our young woman who was trying to get out of Kabul, she had given some money and jewelry to Taliban forces at a checkpoint. There was a generally applicable exemption that covered what was referred to as certain limited material support to tier 3 groups, including situations where, for example, you provided goods or services to members of an armed group in the context of routine commercial transactions. Now, I mean, and I would say these exemptions are also useful to read to get a sense of just how broadly these agencies have been interpreting the statute, because this would apply, for example, in a situation where you ran a restaurant and various Mujahideen commanders would come and eat at your restaurant, as did lots of other people in your town, right? And you fed them all and served them all tea for which they paid you. DHS would consider that to be material support to those guys. So there was an exemption that with the certain limited material support exemption was crafted to cover that. It would also cover situations where, for example, you were providing humanitarian assistance to residents of an area, say in the aftermath of a natural disaster, and you weren't screening people for their status as former combatants, for example, before you gave them blankets and emergency rations. That DHS also would consider to be material support, but they also would consider it to be exemptable under this same exemption. Another one is where is to cover what DHS refers to as, I forget the term, but it's basically normal social interactions that would be considered normal in your society, in your country, and in your society, but where this involves you in giving something to somebody who perhaps would himself be excludable under these trig grounds. So to give you a stupid scenario, but it's a stupid scenario that does recur, you're a young boy living in your father's house and his guests stop by to eat or to see him. And your father says, bring everyone tea, and you go and bring tea, right? If those people are commanders of a local militia, DHS would say that you, the kid, would be subject to a trig bar, assuming that you reasonably should have known and had the maturity to understand that these guys were in fact fighters. And perhaps you didn't. But in any event, you don't really, as a young person, or you're not in a position to say no when your father asks you to bring tea. DHS ultimately understands this. There is an exemption that's available. Now, for a long time, from the time it was originally promulgated in 2014 until 2021, 2022, this exemption only applied where the people in question belonged to, or when the group in question was a tier 3 group. And the policy memoranda, there's a new exemption that was promulgated in response to the Afghan evacuation that also applies this to tier 1 groups. I would say in the course of updating their website for this and also for the so-called insignificant material support exemption, where you gave something to somebody or some group, but it was just tiny, quantitatively tiny, USCIS has done something rather weird where they've taken down the earlier implementation memo for the exemption that applied to tier 3 groups, and they've disappeared the insignificant material support exemption announcement and replaced it with one that actually refers to certain limited material support. And I've gotten a few questions from council out there about what this means. To my knowledge, it means that somebody wasn't proofreading. It doesn't mean that these exemptions are no longer available. And I'm sympathetic to the non-proofreaders because I make these kinds of mistakes on a daily or weekly basis. I'm going to check this, but I think you can find in the Federal Register the original announcement pertaining to tier 3 groups. So it's not the case that if you gave something insignificant to the Taliban, you're now exemptable. But if you gave something insignificant to one of the Northern Alliance member groups, you're not. No. But that said, that does need to be fixed because it is creating confusion to the more careful readers among you. And so I'm giving you here the website where you can find a complete list, both of the situational exemptions and of the implementation guidance that applies to each of them. These also include a couple of other Afghan-specific scenario-based or situational exemptions. One is the one referred to as the Afghan civil servants exemption, and that has been created to deal with a vexing problem, which was that Congress ordered DHS to treat the Taliban as a tier 1 group, right? The problem is the Taliban were the government in Afghanistan for a period of 5 years, and now they are again. And if you are Afghan and you're living in Afghanistan, you don't really have the option of not interacting with them at all. And also what happens if, for example, you had a normal government job as an accountant for a government ministry or something, and you worked before the Taliban took over and you worked while the Taliban were there, you worked after. Does that mean, does your service to your own government, should that be treated as material support to a terrorist organization? I would say I think there's a good legal argument that it actually shouldn't, in the sense that you're really working for the Afghan state, and the Afghan state has a legal existence that is independent of the legal personality of whatever force or party happens to be in control, right? It's not like if you're a civil servant working for DHS, you're an employee of the Democratic Party, for example. So I've never really understood how this statutory problem was really deemed to apply to this particular crowd, but DHS's view is that it does. And they have therefore created an exemption. So that's the good news, is that there is an exemption for Afghan civil servants. That's not going to apply if you were running the army under Taliban control, or doing something that was itself involved in independently in actual terrorist activity as defined in the act. But it will cover the more routine situations that are the ones that we typically see in the U.S. immigration context. There is also an Afghan allies exemption, and that one you should read very closely because it has several parts and it's a bit complicated, and the chronology really, really matters. But that one will allow for an exemption for people who were actually fighting the Taliban, or fighting groups that who were providing support for activities or actions that were directed against the Afghan Taliban or Afghan Taliban affiliated militia groups. That's the first set of acts that can be exemptable under this. Or that were directed against any other organization that was engaged in violent activities targeting the US or allied entities, including, and then they have a series of examples, including entities or contractors of the US government, including the International Security Assistance Force or any successor name of such force, including the United Nations, including the government of the Islamic Republic of Afghanistan, so the previous government, or the Afghan Transitional Authority, during the time period December 22nd, 2001, which is when the Taliban fell the first time, to August 15th, 2021, which is when they took Kabul the second time around. Or that activity that was directed against the army of the Union of the USSR, or the government of the Democratic Republic of Afghanistan. This was the Soviet-aligned government that was in power between April 27th, 1978 and April 28th, 1992. Provided that, and then there are a whole series of preliminary conditions. Now, one thing to be very well aware of here is that this is not going to cover internecine strife between Afghan militia groups during the Mujahideen period in general, right? So if you were fighting against the Afghan Taliban or a group that was affiliated with them, then you may have an exemption available to you here. But if you were in one militia group that was engaged in a turf war against another militia group during this period, this exemption is not going to save you from the INA consequences of that. I often get asked, how can I help my client apply for a TRIG exemption? Well, you can help your client apply for a TRIG exemption by helping your client apply for an underlying benefit, like asylum, for example, and making sure that you get into the record the facts and the documentation that would make clear your client's eligibility for the TRIG exemption. But there is not actually an application process or an application form for the TRIG exemption itself. And the way that this works is that if the case, let's say an asylum case, is pending before USCIS, which the asylum office is part of, then USCIS will spontaneously consider the case for an exemption if the facts fall within a particular exemption that has been implemented. So the statutory exemption authority is broader still than what the agencies have implemented by way of precise exemptions. So, for example, people who fought or provided significant material support to Tier 3 groups are not, in general, going to be eligible for an exemption unless there's a specific exemption relating to that group or that type of group that covers them, which for some Afghans there may be, but for others there may not. And so in that situation, though, USCIS will consider the person for an exemption as part of the adjudication of the case. And that will mean that the adjudication of the case may take a bit longer than you may have been expecting. And I know our expectations haven't been great in that regard, and we'll get to that in a sec. But it can slow down the adjudication process, but they don't actually issue you a piece of paper saying that they've granted you a TRIG exemption. For cases in removal proceedings, though, if any of you have clients in immigration court, DHS is not going to be able to consider an exemption under their process until the person has received an order of removal that it is administratively final, that finds the client to be eligible for the benefit they're seeking, but for an applicable TRIG ground. And also, as I said earlier, all of these different exemptions have different conditions, and you need to read the exemption announcements for the exemption you think you might need very carefully, and also the accompanying implementation guidance. But as a general rule, they're all going to include these 4 conditions that I'm listing up here. So you have to actually be eligible for the benefit you're seeking before the agency is going to consider you from a TRIG exemption. You have to have passed security and background checks. You also have to have fully disclosed the nature and circumstances of any material support or other activity that would give rise to a TRIG ground. DHS usually considers this to mean that you have to have disclosed this in a situation where you were asked. It's not expected that people are going to make spontaneous confessions of chickens that they gave to passing warriors in Afghanistan circa 1996, right? But in situations where you're being asked in an interview or in connection with a government form that poses the question, you need to have disclosed this honestly. And it also is a precondition that you're deemed not to pose a danger to the safety and security of the United States. So if all of those things are in order, then you can be considered for a discretionary exemption. If it's approved, that should also carry forward to any subsequent applications that you make. So if you get an exemption in connection with your asylum application, that should serve you as well in the absence of any changed circumstances or new facts. That should also enable you to adjust to permanent resident status later. And so now I'm going to turn it back over to Rachel to talk about the problem of affirmative cases that are taking more than the 150 days that Congress said they should.
Thanks, Amrin. That was fascinating and super helpful. Um, really briefly, because I know we're coming up on time and there's a lot of great questions in the chat, just wanted to address this issue because it's been coming up for a lot of folks applying for asylum now. That despite the fact that Congress mandated that the asylum office adjudicate these affirmative Afghan asylum cases within 150 days of filing, that really does not seem to be what's happening. The asylum office has said publicly that they are abiding by this 150-day mandate with the majority of cases, absent exceptional circumstances. But how can that be the case if the majority of cases are going past this 150-day deadline? It can't be that every case is exceptional. That's kind of contrary to what the definition of exceptional is. In any event, if you're seeing that your affirmative cases are going beyond this 150-day deadline, you're not alone. We are seeing that for a lot of cases, really across the board. What do? Just as you would, as an attorney for any case, prepare to build your record for litigation. Be aware of how long the case has been pending. Submit inquiries to your local asylum office fairly regularly to remind them that the case is still pending. That the case is still pending, that it's now beyond the processing times that were set by Congress for these types of cases. Once you have inquired a few times with the asylum office, if you get to the point where you're inquiring once a month for a few months in a row, you may want to consider going to your local congressperson so that they can submit an inquiry on your client's behalf. There's a website. If you go to house.gov, you can find who your client's local congressperson is based on where they reside. You may also want to consider going to the USCIS Ombudsman's office. They are not part of USCIS. They can't, they're not going to make sure that the case gets granted because you asked them to. But once you've already been inquiring directly with USCIS, once you've already shown that tried to connect with the asylum office and get a response and haven't been successful in that, you're more likely to see, support from your local congressperson or the USCIS ombudsman to see if they can push the case along. If your case has already been interviewed, it may be a good idea to file a FOIA request, a request under the Freedom of Information Act for your client's A file. You may be able to get, and you can specifically ask for any interview notes from the asylum interview, which may give you an idea of what might be holding the case up. And it may be useful to be able to prepare for whatever comes next. Generally speaking, this is an issue that, like I said, it's happening across the board. We're seeing a lot of these cases taking much longer than 150 days. There's a lot of advocacy going on and, on higher levels with the administration to, push the administration to push the agencies to adjudicate these more quickly. But, if all else fails, put your real lawyering hat back on, and we love to hear about folks filing mandamus lawsuits against the asylum office. Keep in mind, when you file a mandamus case in federal court, the agency does not have a duty to grant your client's application. They have a duty to adjudicate it. So you really want to take mandamus seriously. We don't want to see mandamus petitions filed willy-nilly. But if you have a client that has a really strong case, maybe doesn't have some of the complicating trig factors that Anwen, talked a bit about today, that a case where we would expect and hope maybe it's a little bit more straightforward. Maybe that would be an appropriate case for mandamus once you've already shown that you've tried other efforts to get the agency to adjudicate it and they've failed. Really briefly to talk about temporary protected status and kind of the impact and interplay with affirmative asylum cases. The window is open right now for Afghans to apply for temporary protected status. If you're not familiar with it, it's basically what it sounds like. It's a form of temporary status that allows somebody to stay in the United States for a short period of time. DHS designates temporary protected status uh, for a couple of different reasons. It could be an environmental disaster. Maybe obviously right now for Afghans, it's the extraordinary circumstance of the Taliban taking over their government. They're typically granted in 18-month periods of time that are set by the government and may be extended beyond that, typically 60 days before it's slated to expire. Um, you'll hear whether they're planning to extend that designation or redesignate. To qualify for TPS, you have to have been in the United States already as of a certain date and establish that you continued to reside and been physically present in the United States as of specified dates. So for Afghans, they need to have been residing in the United States continuously since March 15th of 2022 and establish that they've been continuously physically present in the United States since May 20th, 2022. Why are we talking about TPS? Sorry, I should add here that the registration period for Afghans, if they're applying for TPS, started running in May of last year, and it's going to run through November 20th, 2023. If folks are granted TPS, they'll see that expiration date. Everybody will see the expiration date of 11/20/2023, regardless of when they apply. That's the end date for this current TPS designation. Hopefully, we'll see that TPS will be at least extended, if not redesignated for Afghanistan. We'll probably hear about that in September. And then if that's the case, folks will typically have about 2 months following the end of the registration period. So we would imagine it would be kind of the end of November through the end of January 2024 to renew their TPS status. Why are we talking about TPS? This is a great opportunity for folks. There was a question in the chat about this, but if they haven't applied for asylum, maybe this is another way of extending their 1 year filing deadline, tolling it even further. This protects people from removal proceedings. This is another basis for folks to seek and obtain employment authorization. If and when people's parole expires, they have work authorization based on the parole. They need to plan to have another form of relief, another underlying basis to get a new work authorization document. Otherwise, their ability to work will expire when their current work permit expires. Some limitations of TPS are that this is temporary. It's inherent in the name, temporary protected status. It's temporary. They last only 18 months. It's really at the whim of the administration what they're going to do at the end of the 18 months. And in and of itself, it doesn't provide a pathway to permanency, like, for example, asylum and SIV do. For asylum applicants, if your client is already applying for asylum, why do we care about TPS? I think this case is really going to come up when we're dealing with when folks applied for asylum and when they're applying for TPS. And really the question is going to be their employment continuity and if they're trying to avoid being placed into removal proceedings ever. So again, the big issue here we're looking at is EAD continuity, the preserving the ability to work after the parole-based work permits expire. Some downsides, keep in mind that the asylum office generally won't refer cases to immigration court if the applicant holds lawful status at the time that their case is adjudicated. So this is to say, if the asylum office is not inclined to grant the asylum application, if they're planning to deny, there may be some jurisdictional issues if they have lawful status at the time that the application is adjudicated. That in that case, they may just deny it. They may not refer the case to immigration court, and the person might not have the chance to renew it quite as quickly and see their case be adjudicated before the immigration court. This is likely to be an extremely small number of cases, so I'm not super concerned that this jurisdictional issue is going to be a problem. Asylum applicants can file for TPS later, again, just in the case of the 1 year filing deadline, that TPS will toll the 1 year filing deadline for asylum. Having an asylum application pending will allow a potential TPS applicant to file for TPS later if they want to. So really talk to your client. They may want to consider filing, they may really care about their employment authorization. If they do, they may really want to file for TPS so that they can make sure that they have their employment authorization even when their parole-based EAD expires, if they're not going to be eligible for an asylum pending EAD yet. If they're really concerned about pursuing their asylum application at all costs, then they may not want to do TPS now. They want to get their asylum case adjudicated first. Otherwise, they might fall into this jurisdictional gap. We're at time, so I'm going to not go into our hypos here, but um, I assume that the slides will be shared, and if so, folks can see really the idea with these hypos really shows that the timeline matters of when you apply for TPS, if you're planning to apply for TPS, if you're trying to maintain employment authorization.
Thank you so much. And we had some really great questions come up that we didn't have time to answer. So we're going to look into doing a quick answers to the questions in a separate document that we will distribute along with the link for the recording for today's webinar. Thank you so much to Rachel and Enwen. Please stay connected for instructions to get your CLE certification and wait for the evaluation to appear on your screen. Again, to our faculty, Rachel and Emma, thank you so much. And on behalf of the ABA, I'm Emily McCabe. Thank you all for joining us today. And I will now turn it over to Debbie for some additional info.
Thank you. On behalf of the American Bar Association and the ABA Commission on Immigration, thank you for participating in this program. To learn more about the sponsors, visit the ABA website at americanbar.org. Thank you, and please click on the evaluation link.